myself Professor Meenal Sharma and I'm over here to back with the industrial law. Now, we are going to start with your first topic of your Module 1, that is your Industrial Dispute Act of 1947. Now, this particular industrial dispute, this is one of very sensitive issue which we generally fall, easily just not to consider it as a most important part. And this is only the reason where we are struggling with this, and in the end, we come across with a strike or lockout or retrenchment or closure, such kind of issues. When we are talking about your industrial dispute, what do you exactly understand by the term industrial dispute? This particular industrial dispute, this term has basically been defined in your section 2K of your Industrial Dispute Act of 1947. Now, any dispute between employer-employer, employer-employee, workman and workman can be simply been defined as an industrial dispute. One more time, repeating the same thing. जब कोई एक डिस्प्यूट होता है तो एम्प्लॉयर्स के बीच में, एम्प्लॉयर्स और एम्प्लॉइज के बीच में, और वर्कमैन और वर्कमैन के बीच में, दैट इज कॉल्ड एज अ लेबर, इनके बीच में, then it is called to be as your industrial dispute. Now, this particular industrial dispute act has been considered not just into your one part of your state, but it is overall going to be considered, which is equally followed by each and every state, and it is applicable. This 1947 Act is applicable throughout the country. That is even covering all each and every states. Now, when I am talking about the industrial dispute, what was the reason behind why we came up with this concept of your industrial dispute act? Now, the basic first and the most important was to promotion of the measures for securing and preserving and balance or a good relation between the employers and the workers. Second, to investigation and to taking out a settlement between any dispute which is happening in the industries. Third, to prevention of any illegal strike or lockout, because chances are there when two or more people come together, the dispute are supposed to happen, and over that time, so that the smooth functioning is not being hampered, over there we are looking towards that, so that there is no illegal strike or any such kind of issues. And next part is to give a relief to the workmen in matters of layoff, layout or retrenchment, and at the same time, one of the most important objective was to promotion of a collective bargaining. And I'm talking about a collective bargaining, it means together we are going to come to a solution where both the consent of both the parties are agreeing at the same thing in the same manner at the same level. Then it is going to be called as settlement of dispute amicably, where we have understood what is the essence of our mutual understanding, and we will be able to maintain a peace and harmony between the industries. Now, when I'm talking about the industrial dispute and the settlement of the dispute, one of the major part which I'm going to cover now is the duty of the appropriate government. Now, when I'm going to use this term as appropriate government. When I'm talking about the appropriate government, these are nothing but a state government or a central government who are actually required to see to it that yes, there is all the sort of discipline, your understanding of mutual benefit to overall, not just to one industry but all over whoever the people are related to the industry or even outside that. Because once the peace and harmony is going to maintain within the industry, it is going to even create a peace and harmony outside the industry. For that reason, we have authorities under the Industrial Dispute Act of 1947. Now, there are, just remember this, there are 7 authorities who are being appointed by the appropriate government, who are going to look after whether the settlement is being maintained in a proper manner or not. At the same time, they are going to look forward for such kind of things where easily settlements can be done, and each and every time there will be a requirement to reach to a highest level of any high court or a supreme court, and the matter can be resolved at the base level only. Now, let's discuss about the 7 authorities. On this, a question can easily come up in your paper. Who are the 7 authorities? Now, let me check. Now, when I'm talking about the 7 authorities, they are being discussed under from section 3 to section 7. Now, before section 3, there is section 1 which talks about your preamble, which now just now discussed, that your Industrial Dispute Act of 1947, which is going to be applicable to the whole of the country, even if you are covering the part of Jammu and Kashmir. And even the main motto of is that to maintain a peace and harmony and create a settlement of dispute. Section 2, there we are going to discuss n number of definitions. Just once we have done with the authorities, we will discuss about the definitions. Now, when I am talking about these 7 authorities, first, Works Committee, that is section 3. Then, Conciliation Officer, that is section 4. Board of Conciliation, that is your section 5. Then, Court of Inquiry, section 6. Labour Code, section 7. Industrial Tribunal, that is your section 7A. And one more thing, that is National Tribunal 7B. One more thing which I missed out, that is your Labour Code, that is your section 7. Now, when I'm talking about these authorities, each and every authority plays a very important role. When I'm going to this is something which is known as hierarchy. Each and every matter can't be directly gone to a high court or a supreme court. Even they are very much busy with n number of matters, be it civil matters, be it criminal matters. Now, because of that reason, our government has come up with a solution. Why don't we just resolve these issues at the base level only? So at the base level, they have formed a hierarchy, and which coming to the National Tribunal, if they are not able to resolve the issue, then we will directly take this matter to the High Court, and then from the High Court to the Supreme Court. But before even reaching your matter directly to the Supreme Court or the High Court, you are required to pass on these channels of different authorities. Now let's discuss about each and every authority one by one. Now the first is your Works Committee, that is section 3. Do remember, at times your paper is asking about your sections also. Now when I'm talking about your Works Committee, now this particular committee, first of all, is been just understand, ये वर्क्स कमेटी विद इन द इंडस्ट्री होता है, जहां पर एक इंडस्ट्रियलिस्ट अपने हिसाब से अपने ऑर्गेनाइजेशन में, अपनी इंडस्ट्री में एक कमेटी फॉर्म अप करेगा. जब वो कमेटी फॉर्म अप करेगा, दैट पर्टिकुलर कमेटी इज कॉल्ड टू बी एज योर वर्क्स कमेटी. Now when I'm talking about your works committee, it is constituted based on the appropriate government's order. तो हर जगह पे एक authority है, that is the appropriate government, and they are going to constitute. Okay, who is going to be appointed in the works committee, who is not going to be, how many people are required to be there in the works committee, all that has been decided by the appropriate government. Now over here, first of all, it is this particular works committee. Has it to be maintained by each and every industry? No, that is depends upon the works committee or appropriate government. Now this particular act, it will be made applicable to the industrial establishment in which more than 100 workmen are being employed, and it will be applicable even if on one single day there, preceding the 12 months, even on single day there are 100 or more workers. That means to say, एक दिन के लिए भी अगर आपकी इंडस्ट्री में हर 100 और 100 से ज़्यादा वर्कर आ गए, that means to say you will be applicable to make a committee, and that is going to be as a works committee. Moving ahead, it consists of representatives. अब इसमें कौन members होंगे? Representatives of employees and workmen engaged in the establishment. मतलब employer की तरफ से, employee की तरफ से, that is workmen की तरफ से, दोनों की तरफ से कोई ना कोई representatives. And जैसे ही वो representatives आएंगे, these will be number of representatives, which is equal number of representatives. जितने employer की तरफ से आएंगे, उतने ही employees की तरफ से आएंगे, and they will be representing the company. They will be representing their body. That is, employees की तरफ से जो आएंगे, workmen की तरफ से जो आएंगे, वो employees को represent करेंगे. Your employer की तरफ से जो आएंगे, वो employer को represent करेंगे. And that way they will have to conduct their activities. Now, what is this particular committee required to do? Now, first of all, when I'm going to talk about the works committee, they have the duty now to promote measures for securing and preventing amity and good relation between the employer and the workman. उनको देखना है कि employer और workman के बीच में उनको these people are appointed within the organization, within your industry, so they have to see to it that there is no dispute, there is no particular problems between the authorities, and it is being maintained in a very much peaceful manner. Next is to comment upon the matters of their common interest or concern. That means to say, अगर कोई dispute arise होती है, his authority or that is your works committee is going to comment on that. Okay, आपने सही किया है, आपने गलत किया है, there is this issue, please try to resolve it. This way you are going to, promote the peace and harmony. The second body is your conciliation officer, that is coming under your section 4. Again, this particular conciliation officer is been appointed by the appropriate government by notification in the official gazette, appoints a specific number of persons as it thinks fit to be conciliation officer. ये क्या होता है, थोड़ा सा आउटसाइड द इंडस्ट्री में जाता है. जैसे ही इंडस्ट्री के बाहर जाकर के मुझे लग रहा है देयर आर नंबर ऑफ इंडस्ट्रीज, वहाँ पे उस एरिया में, जैसे लेट्स टेक द एग्जांपल इन मुंबई वी हैव एरियाज इन तारापुर, भिवंडी, ऑल दीज इंडस्ट्रियलिस्ट एरिया. वहाँ पे अप्रोप्रिएट गवर्नमेंट को, हमारी गवर्नमेंट को लगता है कि वहाँ पे एक ऑफिसर अपॉइंट करना चाहिए. क्यों? सो दैट इफ देयर इज इशू आउटसाइड द इंडस्ट्री और विद इन द इंडस्ट्री, ही विल गो एंड ऑब्जर्व एंड ट्राई टू रिजॉल्व देयर इश्यूज. So that is why they will issue a gazette, they will issue a document and they will appoint the officer. Now the conciliation officer may be appointed for a specified area or specified industries in a specified area, either as permanent or for a limited period. A conciliation officer shall be deemed to be as a public servant as per decided in your section 21 of the Indian Penal Code. तो वहाँ पे डिसाइड हो गया है कि जो ऑफिसर होगा ये पर्सनली किसी का नहीं होगा, बट दिस पर्सन विल बी अपॉइंटेड टुगेदर फॉर द होल एरिया व्हेरेवर द इंडस्ट्री इज एप्लीकेबल. दैट एरिया में जितनी भी इंडस्ट्रीज होगी उसके लिए या स्पेसिफिक पर्पस के लिए अपॉइंट किया जाएगा. नाउ लेट्स टॉक अबाउट द ड्यूटीज ऑफ योर powers. If you ask me why powers are not being discussed, powers are basically been discussed or just been decided by the appropriate government. So appropriate government जो काम बोलेगा, रिपोर्ट बना के दो, प्रॉपर डॉक्यूमेंट सबमिट करके दो, जाकर के ऑब्जर्वेशन करो, इंक्वायरी करो, all what is required is going to be done by the people or the authorities, the 7 authorities. But duties play a very much important. Now coming to the duty of the conciliation officer. When an industrial dispute exists, the conciliation officer shall hold a conciliation proceeding. वो दोनों पार्टी को बुलाएंगे, बोलेंगे चलो लेट्स डू द प्रोसीडिंग इन अ वेरी मच प्रिस्क्राइब मैनर विदाउट द डिले और टू हैव राइट ऑफ सेटलमेंट. सो वो लोग वहाँ पे क्या करेगा, जितना हो सके सेटलमेंट करने की कोशिश करेगा. Now whether the settlement has been reached or not, the conciliation officer must submit a report within 14 days. किसको रिपोर्ट सबमिट करना है? Within 14 days from the commencement of the proceedings to the appropriate government. तो गवर्नमेंट को उसका काम क्या है, अपॉइंट किसने किया है, अप्रोप्रिएट गवर्नमेंट ने. तो जैसे ही आपको अपॉइंट किया वैसे ही आपकी ड्यूटी हो जाती है 14 दिन के अंदर अंदर आपको उस रिपोर्ट को बना करके सबमिट करना है कि भाई प्रॉब्लम रिजॉल्व हुई है कि नहीं हुई है. Now, if the report submitted is satisfied, appropriate government is okay, they are fine, ठीक है, जो भी आपने रिपोर्ट सबमिट की थी, they can further it may refer to the dispute to any other authority. Suppose if the conciliation officer is unable to resolve the dispute, then this matter can be further passed on to the other authority, next authority. Now, if the government is not making any reference, अगर वो पर्टिकुलर मैटर को ऊपर और लेके नहीं जा रहे हैं, and he feels whatever decision, whatever the settlement has been done is okay, then in that case it should record and communicate the reason to the contended party. यानी क्या होगा कि जैसे ही अगर गवर्नमेंट को लगता है कि भाई ये जो इसने स्टेटमेंट दिया है ऑफिसर ने वो प्रॉपर है, सो वो क्या करेगा, उसको नोट डाउन करेगा, रिकॉर्ड करेगा और उस रिकॉर्ड को भेजेगा दोनों पार्टी को जिसके बीच में डिस्प्यूट था, एंड इट विल बी गिवन टू बोथ द पार्टीज. Now, the duty of the conciliation officer is administrative and not judicial. This is very important for you to understand. Administrative का मतलब होता है जहाँ पर क्लरिकल टाइप ऑफ आपका जॉब, आप किसी को ऑर्डर नहीं दे सकते हो, आप किसी को जजमेंट नहीं दे सकते, या आप किसी को फोर्स नहीं कर सकते कि नहीं आपको ऑर्डर फॉलो ही करना पड़ेगा. बट इट इज जस्ट यू विल ट्राई टू रिजॉल्व द डिस्प्यूट एज मच एज पॉसिबल. Yes. Now coming to the next third person or the third authority you can say, that is your board of conciliation. When I'm talking about the board of conciliation, this is your section 5. Now again the appropriate government by notification in the official gazette constitutes a board. Board will consider number of people. एक बोर्ड में चेयरपर्सन रहेगा, उसके साथ बहुत सारे मेंबर्स रहेंगे एंड देन दे विल फंक्शन. Board of Conciliation for promoting the settlement of an industrial dispute. Their job is simply to promote the industrial settlement. Now the board consists of a chairperson and 2 or 4 or as many number of members as the appropriate government feels. 2 or more as the requirement arises. Now the chairperson shall be an independent person. He will not be decided by any of the authority. जैसे हमने बात की थी वर्क्स कमेटी में रिप्रेजेंटेटिव होते हैं, यहाँ पे ऐसा कुछ नहीं होगा. This particular person will be individual. He will not be considered in any of the matter. He will give his or whatever he feels, so he will give his order as per that. Now the chairperson may be an independent person and he will not be connected with any of the dispute persons. So the other number of members shall be person appointed in equal number as the representatives of the parties or to the dispute. So जितना अभी जो members जो मैं बोल रही थी 2 या 4 जो होंगे वो कौन? These representatives are nothing but the people who are been decided by the parties. यानी जो पार्टीज होंगे उसमें से, जैसे एम्प्लॉयर या एम्प्लॉय के बीच में डिस्प्यूट है, सो एम्प्लॉयर्स जो अपनी तरफ से कोई पर्सन्स को अपॉइंट करेंगे, एम्प्लॉयज अपनी तरफ से कोई पर्सन्स अपॉइंट करेंगे एंड इन दिस पर्टिकुलर कमिटी दीज आर द representatives going to be there. Further, the Board of Conciliation can act only when a dispute is referred to it by the government. This is important. Now, अगर गवर्नमेंट आपको बोल रही है, appropriate government की प्लीज देयर इज डिस्प्यूट व्हिच इज हैपनिंग, उसको जाकर के मैटर को रिफर करो, रिजॉल्व करो और ट्राई टू ब्रिंग आउट अ सेटलमेंट एंड गिव अस अ रिपोर्ट, देन इन दैट केस बोर्ड विल कम इनटू फ्रंट. Now, let's see what are the duties of this particular board. First of all, when a dispute has been referred to the board by the appropriate government, they will start investigating into the matters. They will start taking out what are the merits, what are the rights of the settlements of the dispute, how the dispute has to be, taken out, and if there is any delay, again the board has to give this particular information to the appropriate government. Now, whether the settlement is recorded or not, the board must submit the report. They are going to record the statement, and whether it is settlement has been come or not, they will have to report this to the appropriate government within the period of 2 months. On the date on which the dispute was referred to, within the 2 months from the date the matter has come into force. Now, if no settlement has been arrived, अगर कोई problem resolve नहीं हुई, then the appropriate government may refer the dispute to the labor court, to the industrial tribunal or to the national tribunal. ये कौन आता है? Section 7, 7A and 7B. The time for submission of the report may be extended by such person as may be agreed in writing by the parties or to the dispute and even by the appropriate government. So suppose अगर dispute अभी बीच में है, problem चल रही है and there is a problem where it's going to be resolved or not, and in that case they can say we want an extension period of time. Now the report of the board shall be in writing and shall be signed by all the members of the board. All the members are going to sign for the same. The report submitted shall be published by the appropriate government. जैसे ही रिपोर्ट आती है उसको पब्लिश करना पड़ेगा, किसको? appropriate government को. कितने डेज में? within 30 days from the receipt of that report. Now, a board of conciliation can only try to bring out the settlement. अभी again they can try only to bring out the settlement. It has no power to impose settlement on the parties to the dispute. अगर कोई problem होती है तो they can just try to make a settlement. They can't impose a settlement on any of the parties. Now, coming to the next part of your authority, or you can say it is not exactly the authority but a body which has been formed in it. Now that is your court of inquiry, or you can say section 6. Now the appropriate government. Now क्या होगा कि अगर your works committee, then your conciliation officer या board of conciliation ये लोग problem solve नहीं कर पाए हैं, matter is going to be further represented. So in between, the appropriate government will come up with a solution. They will say the appropriate government by notification in the official gazette. Now, what you will ask me, what is gazette? Gazette is nothing but a document which is being published in the newspaper and in any other article also. Now, this government, they are going to constitute a court of inquiry in any matter relevant to the industrial dispute. They will constitute a court of inquiry, जो inquiry कर रहा है. A court of inquiry consists of one independent person of any number of independent number of persons as the appropriate government feels fit. जितने नंबर ऑफ चाहिए या जो जितना नंबर बिलीव करते हैं appropriate उस हिसाब से अपॉइंट किया जाए. Now the court of inquiry consists of 2 or more members. One of them shall be appointed as the chairman. The court of inquiry can act under as prescribed forum. Even at the absence of the co-chairperson, they can act only if the permission has been given. If the service of the chairman is seized, that means to say stopped for a time being or terminated, the government through notification, the court shall act until a new chairman has been appointed. That means to say, जब नया अपॉइंटमेंट किया जाएगा तब तक के लिए वो जो कोर्ट ऑफ इंक्वायरी है वो स्टॉप कर दी जाएगी. Now all the members of the court of inquiry shall be deemed to be the public servant as per section 21 of the Indian Penal Code of 1860. ये भी मैंने बताया था कि all these people are nothing but the public servant only. Now every inquiry by a court shall be deemed to be the inquiry of a judicial proceeding only. क्योंकि अभी नेक्स्ट लेवल जब हम जाने वाले दैट इज गोइंग टू बी योर लेबर कोर्ट, इंडस्ट्रियल ट्राइब्यूनल और योर नेशनल ट्राइब्यूनल. दैट्स व्हाई नाउ द प्रोसीजर व्हिच इज गोइंग टू बी एज अ जुडिशियल प्रोसीजर. अ कोर्ट ऑफ इंक्वायरी हैज सेम पावर्स एज अ सिविल कोर्ट अंडर द कोड ऑफ सिविल प्रोसीजर ऑफ 1908. जो प्रोसीडिंग्स हमारे सिविल मैटर्स में की जाती है, जैसे सिविल मैटर्स मतलब जिसमें बैंक का डिस्प्यूट होगा या फाइनेंशियल मैटर्स से डिस्प्यूट होगा, फैमिली कोर्ट का डिस्प्यूट होगा, तो जिस तरह से उनकी प्रोसीडिंग्स होती है उसी तरह से इसके मैटर्स की प्रोसीडिंग्स चालू होती है. Now the court has the right to appoint one or more person having special knowledge of that matter of the dispute as an advisor. So वो advisor की तरह appointed हो सकता है if he feels so कि appointment की जरूरत है. Now the next thing which we are going to talk about is duties. The court shall inquire into the matters, refer to it and report to the appropriate government. उसको क्या करना है? इन्वेस्टिगेट करना है और रिपोर्ट करना है within 6 months from the commencement of the inquiry. जिस दिन से इंक्वायरी शुरू की जाएगी उस दिन से within 6 months में उसको रिपोर्ट को सबमिट करना है appropriate government. The report of the court shall be in writing and signed by all the members of the court. The members are free to record their decision. That is to say, if any of the member does not agree to the same thing, they can give their different opinion. The report submitted shall be published within 30 days of its received by the government. So government के पास ड्यूटी है, जैसे ही उसके पास अगर ड्यूटी रिपोर्ट आ जाती है, they have to publish the same. Now coming to the next authority, that is labor court. Now labor court as the term says court, not equivalent to a court, but yes, they are going to function as being given the authorities by the appropriate government and within the jurisdiction of the court itself. Now this is being specified under your section 7. A labor court shall consist of one person only to be appointed by the appropriate government. A person shall be qualified. Now what are the qualifications required? A person shall be qualified for the appointment as prescribed by the officer of the labor court unless he has been a judge. He has to be a judge of a high court. He has been a judge of a district court or an additional district judge for a period of not less than 3 years. Or even he can become a labor court person, chairperson, when he has been into a judicial office, if not less than for 7 years. Continuous 7 years तक उसने अपनी judicial उसमें काम किया है, then even he can become. Now, what are his duties? Now, when I am talking about इसके पहले जितनी भी authorities थी, उनके पास settlement करने का procedure था. जब मैं अगर लेबर कोर्ट की बात कर रही हूँ यहाँ पे, they have to try to adjudicate upon the industrial dispute relating to any matters specified in the second schedule. Now second schedule as per your dispute act में छोटे छोटे matters दिए गए किस किस के बारे में वो discuss कर सकता है. When I'm talking about your labor code, even they are going to discuss about the specified matters which are been given by your appropriate government. Even when I'm talking about they have the adjudicating. Adjudicate का मतलब है जहाँ पे वो अपना comment अपना एक पर्टिकुलर ऑर्डर इस तरह से स्पेसिफाई करेंगे टू द पार्टीज. When an industrial dispute has been referred to the labor code for adjudication within a specified period, it should submit award to the appropriate government. Now, award means to say it is an order. Whatever the labor code wants to give an order, he has to submit it to the appropriate government. Award means to say an order. Now, it shall be published in such manner as the appropriate government thinks fit within the period, again within the period of 30 days from the date of its receipt of by the appropriate government. Now, the next authority is your industrial tribunal, that is section 7A. The appropriate government by notification in the official gazette constitute one or more industrial tribunals. Now they can have one or more industrial tribunals for the adjudication of the industrial dispute, again for giving an order, for trying to resolve the dispute as much as they want to, relating to any matter specified in second schedule and third schedule. In the labor code it was just second schedule. In your industrial tribunal it is both second and the third schedule. Now the tribunal consists of one person to be appointed by the appropriate government. Now the one person shall not be qualified to be appointed as the presiding officer of the industrial tribunal. See, they are not being called as a judge, but they are called as a presiding officer. Unless he should be having, either he should be a judge of a high court, or he had been a judge of a district court or an additional district judge for a period of not less than 3 years. And similarly, no person shall be appointed. Now there is one more additional thing. No person shall be appointed to continue in the office of the presiding officer if he is not an independent person. Means if he is somewhere related to the matter, he will not be appointed for the position. At the same time, he has attained the age of 65 years. Now age bar is there in case of your industrial tribunal and your national tribunal. इसके पहले कोई एज बार नहीं थी, बट इन दोनों में एज बार होगी. So let's see what is the duty of the industrial tribunal. It shall submit its award. Again ये भी award order देगा to the appropriate government within a specified period if an industrial dispute is referred to the industrial tribunal. The award shall be again यहाँ पे period specify नहीं किया है, but हाँ reasonable period. The award shall be in writing plus at the same time signed by the presiding officer. The award shall be again published. एक बार वो जो award order जो देना था वो appropriate government के पास same way में जाता है, within 30 days में publish होता है. Now the judiciary or you can say or industrial tribunal is called to be as a quasi judicial body. Quasi मतलब additional judicial body. It must serve notice upon the parties to the reference by name before making an award. मतलब जैसे ही यहाँ पे क्या होगा, एक ऑर्डर जब भी एक इंडस्ट्रियल ट्रिब्यूनल देने जाएगा उसके पहले वो अपना एक नोटिस भेजेगा. दोनों पार्टीज जो डिस्प्यूटिंग पार्टीज है उनके पास अपना नोटिस भेजेगा. उनको बोलेगा लिसन नाउ आई एम गोइंग टू गिव अ ऑर्डर. और तुम लोग स्पेसिफाई कुछ अपना हियरिंग करना चाहते हो, कुछ स्पेसिफाई करना चाहते हो या कुछ प्रॉब्लम को अपनी रिजॉल्व करना चाहते हो, आई एम रेडी टू लिसन. अदरवाइज आई एम गिविंग एन ऑर्डर नॉट डायरेक्टली. नाउ moving ahead over here, now with this we have finished up with the part of your industrial tribunal. Now next is your last part of your authority is your national tribunal. Now national tribunal, that is your section 7B. As the term says national, it is coming at the central government level. Now this central government, they are going to make a notification in the official gazette, constitute one or more national tribunals for the adjudication of the industrial dispute. Again, adjudication means to say resolving the industrial dispute. Now, this is involving relating to the questions of national importance. ये national tribunal पे ये particular case तब जाएगा when it is concern of the national importance. Now, when I'm talking about the national tribunal, which are of such nature that the industries are more than one state it is going to get impacted or are likely to be in the interest which is going to affect the dispute at a much more higher scale. जब भी मतलब ऐसा मैटर नेशनल इंपॉर्टेंस पे आता है तब ये नेशनल ट्राइब्यूनल पे चला जाता है. Matters appearing, now it is going to again cover up matters covering both in the second schedule and the third schedule. A national tribunal is going to have one person to be appointed by the central government. A person shall be qualified for appointment as a presiding officer of a national tribunal unless he has been, now it is one single thing which is very important, unless he has been a judge of a high court. Until and unless he has been a judge of a high court, he can't be appointed as your national tribunal presiding officer. No person shall be appointed as or continue in the office of the presiding officer in the national tribunal if he is not an independent person or if he has attained the age of 65. यानी जैसे ही अगर आप 65 एज अटेंड कर लेते हो वैसे ही your position coming to the part of national tribunal gets stopped. Now, last part, that is your duties of the national tribunal. First of all, it is similar to your industrial tribunal only. So when an industrial dispute is referred to the national tribunal for adjudication, it shall submit an award or the order to the appropriate government. Now the award order shall be in writing, it shall be signed by the presiding officer of the national tribunal, it shall publish the award within a period of 30 days and from that date the receipt of the central government, it will be again published. This is, even if after this the problem is not been resolved, the problem will now further go to High Court of the Supreme Court. This was the concept of your 7 authorities in your Industrial Dispute Act of 1947.